good morning from London, good afternoon, good evening from anywhere else in the world you might be joining us. I'm just going to give a few minutes just to allow attendees to join before we start the webinar today. You can see more attendees joining. And as we say, please do drop a note in the chat. Tell us where you're from, you're joining from today. It's always great to hear the diversity. I see somebody already. Good morning from Paris. Very good morning to you. Hope it's sunny in Paris. It's sunny here in London. I'm loving all the diversity showing up already on the chat. Thank you. Lovely to hear from you. Somebody calling from USA up bright and early this morning. Lovely to see you all. All right, well, let's get going. We're just 1 minute past the starting time. So good morning, everyone, and welcome, a very warm welcome to Breaking Barriers, Opening Doors, Equality in Arbitration Appointments. I'm Lucy Greenwood. I'm an international arbitrator and I'm trustee of the Chartered Institute of Arbitrators as well. Absolutely delighted to be participating in this panel today. But thank you again to everyone who's joining from across the globe. So today's panel takes place to mark International Women's Day 2026. International Women's Day, one of my favourite days of the year. And this year, the UN focus is on rights, justice, action for all women and girls. And this is essentially emphasising how equality is foundational to fair and effective systems of justice and leadership. And really, that's what we're going to be trying to focus on today. As many of you will probably already know, this year's tagline is, if you didn't already know, it's #GiveToGain. And that's really the sense that when we give support, opportunity, mentorship, and allyship to one another, we really get so much back in return. We get better institutions, better outcomes, and stronger communities. And this is really resonates very much with the discussion that we're going to have today for the next 90 minutes or so, because achieving true equality in arbitral appointments really requires the support of the entire arbitration community. And whilst we hope that we have that and we have a lot of momentum behind us, it's really important to keep that momentum going and to ensure that access to appointments is open, equitable and based on merit, and it's not derailed by unconscious bias, complacency, or certain sort of, I would say now, very outdated patterns of behaviour. So as you can probably tell, this is a topic I am really passionate about, and I am absolutely delighted that we have such a stellar panel joining me to discuss this today. So they will all, I hope, introduce themselves when they first begin to speak, but just by way of a quick overview. So Sapna is based in Singapore and she is a chartered arbitrator, a member of Blackstone Chambers and also a judge of the Court of Appeal of the Courts of Dubai International Financial Centre. Kevin has, I think, fairly recently relocated to London from Singapore, and Kevin is now the Director General of the London Court of International Arbitration. Caroline is also a chartered arbitrator with chambers in Melbourne and in London, and is also a fellow trustee of the Chartered Institute of Arbitrators with me, so that's very nice to see Caroline again. And Ravi is a barrister and arbitrator and a member of 36 Stone Chambers in London. Now, I'm particularly delighted that although this is a panel to mark International Women's Day, we've got Kevin and Ravi with us. And it's really important to do that because this conversation is not just about women. It doesn't belong only to women. The responsibility to examine how arbitration appointments happen, why the disparities exist, and how they can be addressed is very much something that is shared by all of us. So with that, let's talk about what we're going to cover today. We're going to start by framing the discussion with a look at the data, where we were when I first started looking into this issue, which is, going back to 2012 was the first paper I wrote on this, and how we've got to where we are now and potentially where we could be in the future. Then we're going to look at sort of how appointments happen in practice. We're going to touch on where exactly the gap is, and also very particularly why we should care about closing this appointments gap, which again is something that I feel perhaps isn't particularly talked about in sufficient detail. And finally, and most importantly, we're going to talk about what we can do about the issue. But let me say at the outset, this is an interactive panel discussion. You have, as I say, a stellar group of panelists with immense experience, not just in relation to this topic, but in international arbitration across the globe, going back many, many years. So please do use them. Drop us questions in the chat, and actually Chartered Institute will wrap me over the knuckles for that. Put them in the Q&A box. They're easier to manage there. You've got a Q&A bottom along the bottom of your screen. Please do use that. And I'm going to be putting some questions to our panelists to get the discussion going. But what we'll try and do is monitor the chat and the Q&A and pick up your questions as we go along. So with that, let's start with this framing of the discussion and looking a bit at the statistics and the data in relation to arbitral appointments. So I'm going to ask Kevin, with his institutional hat on, to kick us off with a snapshot of where things currently stand and really where you see things moving in the next sort of short-term 5 years or so. Kevin.
Sure. Thanks, Lucy. This is an important topic, and important enough that I will get up early after a long transit back from Mexico City. So thank you to you. And Lucy, really, you've been such an important voice on this issue. So let me try to give the lay of the land from an institutional perspective. For me, I was an appointing authority for more than a decade under Singapore law and the SIC rules, and now I deal with appointments as Director General of the LCIA. So I'm on the front lines, and I've seen the evolution in terms of diverse appointments. And I'm happy to say that I've worked with every panelist here as arbitrators, including some that I've appointed in my personal capacity. Maybe I'll start by sort of putting a question out to the audience, and you can answer in the chat. And I would ask how many of you have agreed to the LCIA EDI guidelines in an LCIA arbitration, or in fact in an arbitration administered by another institution, because the EDI guidelines could be modified to use in any arbitration. And so if any of you want to answer whether this has been used, because I think these EDI guidelines are not being used enough, and it shows that we have made really good progress, but I think there's more work to be done. So when you're looking at diversity, or when I'm looking at diversity...
Kevin, before you do that, perhaps it might be helpful if you could just perhaps explain to people who may not be entirely familiar with them the EDI guidelines just very briefly before you go on.
Yeah, I mean, the EDI guidelines were introduced by the LCIA, and I had nothing to do with this, but effectively they are establishing the EDI guidelines as core values of the LCIA and offering ways to increase diversity and access, not just in arbitrations, but also in leadership, and also at events, outward facing roles. So this is something they are non-binding, but something that really sort of show the pathway for LCIA, and you can see these on the LCIA website. So this is something that we want to see agreed to, and really is codifying what lots of us are doing and establishing that pathway. So let's take a look at the statistics and see where we're at, and I'll speak both from a Singapore and London standpoint. So for me, when I'm looking at diversity, I'm looking at geographic, generational, gender, and then also the intersectionality of these diverse characteristics. So all of the institutions are doing quite well. So if I'm looking at it from an LCIA standpoint, I think the advantage of LCIA, and what really shows the robustness of the caseload, is that LCIA is appointing a lot of arbitrators. Part of this is because of the profile of LCIA's caseload. So we appoint more three-member tribunals. So it's about 54% three-member tribunals versus sole arbitrators. We also have an advantage in terms of the appointment philosophy at LCIA, is there's a lot more three-member tribunals being appointed by the institution. And I may circle back to this later, because this gives a very good or possibility to appoint first-time arbitrators, because you can appoint a first-time arbitrator as a co-arbitrator rather than that very lonely place as a sole arbitrator or as a first-time presiding arbitrator, because typically institutions will just do this in a multi-party case following the really the sort of DUTCO jurisprudence, but LCIA will often, if the parties have not agreed to a nomination procedure, LCIA will appoint all three arbitrators. The LCIA court in 2024 made 38% of the appointments, 46% by the parties, and 15% by the co-arbitrators. Now, when you see what that looks like for gender diversity, the LCIA court, in effect, has gotten to gender parity. So in most every year, the LCIA court would be appointing around 50% arbitrators, 48%, 46%. I think what's very good at that, when I'm talking to Maxi Shearer, the president of the LCIA court, LCIA has been appointing women for so long. It's not really something that we look at because diversity is so embedded in the LCIA appointment process. And this is really important because it's not something that an institution can just decide to start doing the next day. We have been building up this roster of diverse arbitrators. And so it's something that is affected in every appointment at LCIA. LCIA is also very good at making first-time appointments, and this is a piece of data that not all institutions publish. So 14% of LCIA's appointments in 2024 were first-time appointments in LCIA arbitrators. So in terms, Lucy, in terms of where we are going to be in 5 years, I think that arbitration is becoming increasingly international. And I think that the gap between the institutional appointments, party nominations, and co-arbitrator nominations really has a lot to do with data. So the reason why LCIA is making diverse appointments is because we have the data that show that diverse appointments, diverse arbitrators make for better arbitrations. And maybe I'll close this question with a bit of a passion project of mine, and that is the unequal exchange in appointments. And this is something that I noticed when I was in Singapore. So when you're making an appointment in Singapore with an Asian institution, often the institutions, as a matter of course, will appoint a European arbitrator, even if there's not a nexus with Asia. But that is not happening in the opposite direction. So if you have a European arbitration, they are not typically going to appoint an Asian arbitrator. And in this increasingly global world, we do not want to run into patterns where we're really appointing based on history, based on legacy, rather than appointing on performance.
Absolutely, Kevin. I mean, that's really, really inspiring to hear that. I'm going to, before I move to Caroline, I am going to ask you a little bit more on your point about data. I completely agree with you. You know, this is all about having the data to monitor the trends and the progress, and that was a real problem that I faced when I first started researching this back in 2012. But when you say you've got data to show that to paraphrase, diverse tribunals do better, help us understand what that looks like a little bit.
So, Lucy, we're actually trying to assemble the data. So we're currently reviewing around 2,000 awards in LCIA arbitrations, and we're looking at the performance of institutional appointments versus party-nominated appointments. To my understanding, this has not been done before in arbitration. So is there a difference when the institution is making an appointment when we appoint a diverse tribunal? Say, if we appoint all three arbitrators, are there less minority opinions? Are there less challenges? Can we see that institution is actually running with more efficiency? I always give the example of geographic diversity and of understanding the business culture. And I look at, say, if you had a construction project in Malaysia or Singapore, and you had an arbitrator that wasn't au fait with the business culture and the commercial realities in that jurisdiction, they may end up incorrectly assessing the credibility of the witness. If you had a witness that was saying that, well, we never wrote anything down, we always did oral variations to an arbitrator that didn't understand that business culture in the ASEAN, they may think that witness was not being truthful. Whereas someone who understands the business realities there and of how that's actually conducted, and that oral variations on projects would be happening all the time. So it's really important. And I think you can start at that example and you can really run the gamut in terms of how an arbitrator is going to interpret a case and decide a case. And in general, because we operate in such a diverse system, that a diverse arbitrator will invariably be well placed to make the better decision there. But we need to have the data backing. I don't think it's good enough from a qualitative standpoint to say that this is better. We need to be able to show the numbers.
Absolutely agree, and I'm, as I say, so excited about that research that's going on. I mean, from my personal perspective, having sat on tribunals who very much look and think and sound like me, and tribunals who have been incredibly diverse. It's that thing, if we're all thinking alike, nobody's really thinking. And I have certainly found that sitting on diverse tribunals, and by diverse I mean, cognitively diverse, diverse legal backgrounds, non-lawyers, all sorts of it, encompassing all forms of diversity, there can often be slightly more friction, and the discussions can be more robust and more challenging. But am I in any doubt that it has led to a better, more thoughtful, more analysed award? No, I am not. It might be harder work, because it is more difficult to work with people who perhaps challenge your natural instinct and things. But yeah, I've personally found it very, very useful and producing a very different outcome. Thank you so much, Kevin. Let me bring Caroline into this, and I appreciate we've got a very helpful comment from Erica Williams on statistics in the chat, which I will draw people's attention to. Thank you so much for that, Erica. But let me bring Caroline in on this, and I want Caroline to help us sort of look from a historical point of view, because Caroline has been in the legal profession for over 35 years and sitting as an arbitrator for more than 15 years now. So she's very well placed to talk us through where things were and how we've got to where we are now. So Caroline, just talk us basically through your experiences of the challenges that women in particular have faced in being appointed, and sort of generally your thoughts on challenges of developing and maintaining a career in the law.
Good morning, Lucy, and to everyone, and thank you to Ciarb for inviting me to join this panel. So I think the problem that women has faced historically is because at a very basic level, arbitrators are predominantly drawn from the legal profession. And going back 30 years ago, the legal profession was predominantly a male profession. So, when I started in the law, there were very few senior women, no judges at all, no female judges. And so I think that what has happened is historically is that arbitrators have been seen as a male-dominated profession, and I think that this is now changing over time as more junior female lawyers become senior lawyers, become partners, become judges. They have changed the face of the legal profession, and we have now seen so many, competent lawyers such as yourself, Lucy, and Sapna, put their hand up to be arbitrators. And I think now, as Kevin was saying, that diversity is seen as a necessity in this day and age, and it's also appreciated that women make a highly valued contribution. So I think that law firms now, when they're making party appointments, are considering the whole range of who might be appointed as arbitrators, and that includes male and female. And I've also seen that in my practice as a barrister.
Thanks very much, Caroline. Sorry, I'm slow to come off mute there. No, that is really a very succinct and sort of analysis of how things have progressed. And when I was looking into this, I thought there was a lot of challenges and a lot of attrition. We have pipeline leak, as you allude to, but then women also I found faced an additional hurdle in getting those early arbitration appointments. So once you've got your way, you've managed to get your way up to the point that you can start, as you say, taking appointments, then certainly 10 years or so, there was a significant additional barrier to getting that very first appointment. And I think that barrier has come down a little bit. But let me bring Sapna in to talk generally about what really drives getting an appointment. We know how hard it is, and I'm very conscious that it is a bit of a black box. Much more transparent with the institutional appointments, but LCIA being slight outlier in this, most institutions don't appoint that many arbitrators. The majority of appointments come from party appointments, and as Erica has mentioned in the chat there, she's shown the stats which show the disparity between party appointments and institution appointments. So let me turn it over to Sapna just to give us some sense of where appointments come from and how you can best maximise your chance of being appointed. Sapna.
Thank you so much, Lucy. It's great to be here to celebrate International Women's Day with this panel and with the audience. I have to apologise in advance. I have a dog scratching in the background. So I'm sure our diversity encompasses non-humans as well. So I hope you'll all excuse me if that gets loud. So, well, there's two sources of appointments for arbitrators, as we all know: institutional appointments and party appointments, and presiding arbitrator appointments could come from either of those buckets. And I've been thinking about, what do parties look for? What do institutions look for when they're looking to appoint someone? And I think that across both buckets, what's critical is that there's some trust that you're going to be a good and competent arbitrator for the case at hand, whether because of your experience, maybe you have a particular niche, but I think trust underlies the choice of an arbitrator for an appointment. And I think institutions can be more risky because they can mitigate any risk by giving, for example, a first-time arbitrator a small case to deal with. They could supervise the case closely. They could hold the arbitrator's hand. But I think parties are much more risk averse. And I think that the way that it tends to work in practice is that an arbitrator will start getting their appointments from institutions, and then eventually and hopefully will graduate to party appointments. But I think it can be quite difficult to make that leap and to get parties to trust you. And perhaps we can talk about how that can be done in practice. But I'll just end maybe with giving a couple of examples from my own experience about how I started my arbitrator career. I got my first appointment from the Dubai International Arbitration Centre just after the financial crisis. They had thousands of cases because the real estate market had crashed, and all of these real estate contracts between purchasers and developers had arbitration clauses. They just couldn't find enough arbitrators. So they appointed me because I had had several cases as counsel before the institution, and they knew that I would be a safe pair of hands. So I think that's what institutions are looking for in the first instance. And then the final example is, once I'd had some experience as an arbitrator, I thought it would be nice to expand my portfolio to other institutions. And I attended a seminar by a very well-known arbitral institution, and I approached the head of their team and introduced myself and said, I've sat as an arbitrator a few times, and I wondered if you might possibly give me a case or might consider me. And I still remember there was a pause and a long silence. And this is quite a prestigious institution. She sort of looked at me like I was mad, like I was from Mars, because she didn't know me. And that level of trust, of course, hadn't been built up. During the seminar, I asked, I think, 2 to 3 very pertinent questions. And she came up to me after the seminar and said, you know what, Sapna, I might have a case for you. And I like that example for 2 reasons. Firstly, if you don't ask, you don't get. But secondly, how are you going to show institutions that you are a safe pair of hands, you do know about arbitration procedure, and you would be a competent arbitrator? So I think it's easier with institutions, but we can talk about how to get parties to trust you.
Thanks, Sapna. No, that's a great anecdote and really shows the importance of visibility in this small market. And I know we're going to come and talk about that, and perhaps we'll circle back a little bit to that later on. But let me bring Ravi in. Yeah, Ravi acts, as I mentioned, as both counsel and arbitrator. And when Ravi, when you're sort of advising clients as to who would be a good safe pair of hands, to use Sapna's phrase, for an appointment, what's your sense of how risk averse they are? Because again, and we're going to talk about this, I hate using risk as a shorthand for a diverse arbitrator. It isn't a risk in my mind. We have a great pool of highly qualified, experienced diverse arbitrators, but you still occasionally get this sense from clients that they do see it as something of a risk. So let me bring you in on that, Ravi.
Thank you very much. Good morning, good afternoon, good evening, everyone. It's a pleasure to be here. Thank you to the Chartered Institute. I am grateful for the question, Lucy. And yes, subject to the big qualification about the term risk averse, let's run with it for the purposes of answering the question. I think clients do tend to be very risk averse. And we've all, I'm sure, heard the example of IBM. It's often said in response to questions of this type, well, if I get my computer equipment from IBM, no one can criticize me because it may be expensive, but it's the best and it's not going to go wrong, and the service will be excellent and the like. And the reality is, I'm afraid, I don't think that example translates well into the demands of arbitrators in modern international arbitration. And of course, again, underlying all of this is some sort of assumption, which in my view is very faulty, that if you go for somebody who isn't one of the usual suspects, to use your phrase, Lucy, that then somehow that necessarily involves compromising on quality. Now, there have been a number of initiatives to increase awareness of more diverse potential arbitrators, and they are gaining some traction, which is excellent. I have in mind a number of pledges, which I'm sure many of us are all signatories to, and which will be well known to our audience today. But I'm afraid there is a bit of a problem here, because don't get me wrong, pledges and similar initiatives are, in my view, hugely important. But we seem to have walked into a state of affairs where signing them has become quite performative. And people are saying all sorts of great things on LinkedIn, that they are delighted that their organization has signed this particular pledge. And indeed, they'll stand up at conferences and say that they've done this. But are they actually modifying their behaviors in relation to what those pledges require? I would say progress on that front has perhaps been a bit slower. So we're in a situation, I would say, where it's great that we've got the awareness out there, but we do need to encourage as best we can, and I know it's another question as to how we can encourage parties actually to act upon those pledges, realize that increasing diversity does not somehow entail decreasing quality. And something which Kevin said is something which brought this example to mind. And I've seen this a number of times at conferences where you have very senior and well-regarded general counsel or senior lawyers in private practice who are very happy to stand up at conferences and say, well, we want more women, we want more non-lawyers, we want more African arbitrators for our Africa-related disputes, we want more Asian arbitrators for our Asia-related disputes. But it's very easy to say that in the abstract, isn't it? The point is, what do those very same people do when it comes to appointing an arbitrator in their own case? And I'm afraid there it becomes a little bit more awkward very often. And I have tried to have this conversation with a few people and say, well, you've got your own dispute now in the offing. What are you going to do? Are you going to appoint a woman? Are you going to have a non-lawyer? Will you have some regional diversity? And it does get very awkward. There's almost what I like to call a reverse snobbery. And they'll say, well, hang on, what's wrong with us? What's wrong with our money? Why can't we have Toby Landau? And of course, you can have Toby Landau if that's what you'd like to do. He's a brilliant arbitrator, and party autonomy remains very important in this discussion. But my point is, we need to take a step back and take the progress we have made in disseminating pledges and knowledge and initiatives like that to the next stage and get people to modify their behavior, which I know we're going to come on to in a later question. Thank you.
Thank you, Ravi. And, I think as you're talking, I'm thinking perhaps some of this maybe I'm putting too much on the LCIA and Kevin's shoulders in this, but some of this may be plugged by the research that the LCIA is doing into data, because constantly with this, in this market, we are plagued by a lack of transparency, I think. And I am absolutely the biggest proponent of confidentiality in our disputes. It is the cornerstone of what we do, and it is the reason why we're all able to do it, in my opinion, because you have, GCs of large companies do not want their disputes aired in public. But that doesn't mean we can hide behind the confidentiality shield all the time. We need to be transparent in situations that do not impact business secrecy and confidentiality, and be able to be more aware of the data that Kevin's doing the research into, which is hopefully going to show that diverse tribunals produce better outcomes, however you define that. But also, I think, being more transparent in terms of arbitrators' busyness, efficiency, reputation. I see perhaps historic reputations not necessarily matching up with current availability, or even people tailing off towards the end of their career. And so question really to Ravi probably first is, how easy is it to get reliable information on reputation is probably the wrong word, but on an arbitrator's experience and competence. So I'm very conscious that a lot of this is word of mouth. It is inherently unreliable, and although we do have databases that we can interrogate and things, it's not an exact science. So help us with a little understanding of that aspect.
Thank you, Lucy. Well, I'd agree with you. It's easy to get information about certain arbitrators, but as to the reliability of that information, there are some big question marks. As you've already alluded to, there is some information out there, but it's all very subjective. If people are having discussions behind the scenes, it's easy to see how that may be skewed, to go back to your phrase, in favor of the usual suspects who perpetually get appointed and may perpetually get good feedback about their performance. But very often there's more to it than that, isn't there, behind the scenes? We don't necessarily know how long those awards took to take from composition of the tribunal. I would say anecdotally, if you go for 2 or 3 of the usual suspects, you could be waiting a lot longer for your award. But often that's missed in the discussions about the fact that the award, when it eventually did come, was quite good. Do we know how much of that usual suspect's work is being done personally by said usual suspect, and how much is being delegated either openly to a tribunal secretary, or perhaps even behind the scenes, which we all know shouldn't happen, but it's a pretty open secret that that is happening. I would say there are sources. There is Jus Mundi, there is Art from Global Arbitration Review. But going back to your question, I'm not sure how reliable sources like this are, because their range, the survey sample, is quite limited. I think it's fair to say it's only bigger and more prominent cases which would otherwise attract the attention of Aswani and Gar, which would get feedback on the arbitrator's performance. And as I've said, it's all very subjective. I've yet to see anything bad written about anyone in any of these sources, but it can't be the case they're all performing at 100% all the time. So where is the constructive criticism? There is something I think we need to do to improve as a community here. I don't have the answer because, of course, as you say, we do have to be mindful of considerations of confidentiality. But let me just throw this out. It goes back to this risk averseness and concern about what happens if it all goes wrong, if I appoint a less experienced arbitrator. Again, let's question our assumptions. Why is the starting point that it will go wrong if you appoint a diverse or less experienced arbitrator? That assumption is itself faulty. Speak to anybody who has given someone their first or second appointment, and I can almost guarantee they will tell you, well, actually, we had a fantastic experience with this arbitrator. They were polite, they were responsive, they took time to understand the issues, they accommodated everybody's needs and requirements, and they produced a very quick award, turned it around, and the award, whether we lost or won, of course, is a different question, but the award was impeccably reasoned and they did very well. That's the story we as a community should be sharing, success stories of first or second time or more diverse arbitrators. How we square that with confidentiality is, of course, a discussion we need to have. But we need to find ways of making sure that experiences, good experiences of diverse arbitrators are disseminated. That's how you make sure an arbitrator's career doesn't end or stagnate on appointment 1, but goes on to appointments 2, 3, and 4. That's really, I think, as a community, something we need to be thinking about, because at the moment, reliable information is just not really there, I'm afraid.
Thank you, Ravi. Yes, I completely agree with your points, and let me bring Kevin in on this, on your point about good experience need to be shared. I would also entirely endorse your comments about bad experiences need to be shared, but obviously that's a little more challenging and provocative, perhaps. But Kevin, in turn, when an institution's making an appointment, and obviously you don't need to confine yourself to the LCIA on this, are you able to give our audience a sense of what drives the shortlist there, and really how you get onto that initial shortlist for the institution, whoever it is in the institution who's thinking about who would be good for this case? How do you get onto that initial list?
Yeah, maybe I'll start by saying with the good experiences versus bad experiences, I think it's important to note that institutions actually do talk to each other. My personal philosophy is that I will share good experiences rather than bad experiences, because I think sometimes that can be context specific, but institutions should not have arbitrators that they know very well are high performing, but the rest of the world hasn't found out yet. So getting on the shortlist for any institution, to a certain degree, for any arbitrator, you are entering into a very long-term relationship with an institution, and we want all of you to like LCIA maybe slightly better than any other institution, but the reality is you need to have relationships with many institutions, and so you would look where you have a comparative advantage, from sectoralization to region. So in terms of how we're making the appointments, and I think part of the reason why there is this gap in the diversity statistics is because we have more data. So when we're making an appointment, we are drawing from thousands of appointments. And I think what is important to be very clear about is I think any institution is not going to be appointing based on reputation. So you can look at any number of CVs, or if you hear about a reputation in the market, what we want to have is that firsthand experience. So if the LCIA court is making the appointment, that an LCIA court member has been opposite, someone has had counsel before them, or has sat on a tribunal. So institutions are almost never appointing off CVs, and you really want to have an understanding of that arbitrator as a person. So I think it's really important to get to know the institution. So when we're making the appointment and making the shortlist at the LCIA, we're drawing from the LCIA database of arbitrators, but like any progressive institution, you need not be on the LCIA database. So it's an open appointment system, the same as institutions that have a public panel. They're not going to be confined to that list. So when I was making appointments in Singapore, I mean, there is sort of a way that you do things. So you're looking at the sector, subject matter, quantum, seat and governing law. I think a useful proxy for institutions is always going to be common law versus civil law, although every time I say that I use the governing law of the contract as a proxy, then I will have a common law arbitrator that will tell me how they also sit on civil law governed cases. So it's not a rigid categorization, independence, availability. And sometimes it's a soft factor where you're actually looking at what the parties might view this appointment as. So if each side is looking at the appointment, say, of a sole arbitrator or a chair, and each side would say, yeah, I think I can get a fair adjudication of my case with this arbitrator. Sometimes it will come down to that of how the parties are going to view things. I should also say in terms of counsel work that something that is underused is the making of proposals. So that could be a diverse quality, or it could be an experience metric. So I often will see, or would often suggest, that a counsel might be able to say the moving claimant would say for the appointment of a sole arbitrator, we think the sole arbitrator should have at least 20 years of experience and experience in this industry. And then the respondent typically would not agree and might say, no, we think it should be these other qualifications, or the arbitrator should not be a national from this jurisdiction. And the institutions almost always are going to try to give effect to both of those proposals. So this is different than agreed qualifications, but if you keep those proposals general, I think it can be helpful. And you absolutely could make a proposal that the institution should take into account diverse characteristics when making the appointment. So the short list for institutions, it is a bit of a black box, but we spend an enormous amount of time on appointments. And I would actually say, from a personal standpoint, I am much more interested in a very small value dispute. So if a 10,000 pound dispute comes down the pipe, now I'm starting to get very interested, because if it's a multi-billion-dollar case in a specific area, the list that we're starting with might be 10 or 15 arbitrators that we would be looking at for that appointment. But if it's a smaller value appointment, now I can start thinking, who is the best senior associate that we've seen doing great work as second or third chair that deserves this first time appointment? So sometimes those smaller ones can actually be a lot of fun for an institution.
Absolutely agree with that, Kevin. No, thank you very much. And there is no doubt how much time and care the LCIA spends on its appointment process. I mean, it is, as we know, the most important question that the parties have to answer is who their tribunal is going to be, and getting the right arbitrators is fundamental. We're having some great questions both in the chat and the Q&A, so thank you all so much for that, and really interesting comments. Let me group a couple of questions together, which again comes back to this sort of notion Tina, I think, has referred to it as a business case for promoting more diverse arbitrators. I think that's a very good way of looking at it. In the absence of this ongoing research, let's talk more broadly about that. How, Tina says, how do we suggest case administering organizations make the business case to promote more diverse arbitrators? And there's a similar question about how the Chartered Institute, but I would also say the arbitration community more generally, how we can better improve the mindset of parties so that a tribunal can become more representative and inclusive. So let me invite Sapna, maybe, or Caroline, to come in on those two questions, which are kind of grouped together there. I think, Sapna, go ahead.
Great questions. And I'd like to answer, or start the answer, by picking up on a couple of the points that Ravi made. You see, when I started my career in international arbitration, it was very much the usual suspects. There was probably a pool of 20 to 30 arbitrators who got all the appointments. And of course, the pool of arbitrations was much smaller then, but arbitration has proliferated. And the reality is, we still have, I would say, a layer of very, very busy arbitrators who have proved themselves by being very good, But the reality is there's a limit to how many cases they can take on. And one of the great drivers, I think, for having a more diverse pool of arbitrators is so that we get people who can give full attention to their cases, can get awards done in a prompt way, and can do at least the important parts of the work of an arbitrator themselves without having an army of secretaries, which some arbitrators have, doing the work in the background. So I think it's really important to recognise that in our field, diversity is really important, and will contribute to quality by making sure that we're getting the right attention on the cases. There's also the second driver, of course. We all know the statistics from boards that a diverse decision-making body will produce a better outcome. We don't have great data for our field, but I'm looking forward to the data that the LCIA is working on to prove, frankly, what we know, as you say, Lucy, when you've sat on a tribunal with people who have a different perspective from yourself, it can be challenging, but you know that what you're going to end up with is a better reasoned decision, because everyone won't have come with the same assumptions to the table when you're making the final decision for the award. And finally, when I think about diversity, I think about one of my role models, the former Chief Justice of Canada, Beverley McLaughlin. She's been a huge promoter of diversity in the judiciary. And as well as pointing to diverse decision-making bodies producing better outcomes, she also looks at issues such as when the judiciary became more diverse in Canada, people had more confidence in the judiciary, there was more trust, more legitimacy. And I think it's important for us to always safeguard the legitimacy of our system. It's going to be better, it's international, and it is going to be better if it reflects the parties and the people who come before it.
Absolutely, Sapna. And Sapna, I think, again, this isn't talked about, and Kevin alluded to it early on, but, you know, the real importance of the most important people in the room, which are the clients' representatives, you know, being able to see reflected not just in the tribunal, but in the room as a whole. People that are similar, you know, look and sound like them. It's important, not talked about enough. Let me bring Caroline in on this generally. Caroline.
Yeah, thank you, Lucy. So I think just going back to something which Sapna said about her first appointment, my first appointment was also from an institution. And I think institutions have played an enormous role in closing the gap between male and female appointments. And I just wanted to share some statistics from the ICC showing the upward trajectory in the appointment of women as arbitrators. And before I share those statistics, also to mention that the ICC have now sort of endorsed more transparency. And as far as I'm aware, they're the only institution that actually publish the names of the arbitrators which are appointed. And I just wanted to share that because we have spoke about the need for transparency. So in 2023, according to recent statistics, women comprised 29.7% of all arbitrators appointed by the ICC. However, in 2024, statistics show that women accounted for 46% of all ICC court appointments. And of this, women represented 43% of sole appointments or presidents, but only 20% of co-arbitrators. So this would seem to indicate to me that the parties are still appointing male arbitrators. And that's something that Erica Williams from Australia has mentioned also in the chat room. So I think what I'd like to say is that institutions are playing an enormous role in actually promoting diversity. And um, I think they need to all of them need to adopt more transparency and endorse this provision that the ICC has in actually publishing the name of their appointers, so that we can see, the arbitration community can see that institutions are not just appointing the same arbitrators. And I might say that, you know, in my experience, I've seen some horror stories about the delay in producing awards because the same arbitrators are being appointed, and that should not be happening. And we can only sort of change the position if we have more information about appointments.
Thank you, Caroline, and that's super helpful to highlight the discrepancy that we've touched upon throughout this discussion, which is between the institutional and chair appointments even, but it's the party appointments that really do lag behind. And, you know, I suspect it's going to have to be a sort of, you know, number of fronts that we attack on that, whether it is the, you know, Ravi's point about risk and you don't get fired if you choose IBM, how we get round that, or calling out the good behavior from the institutions and really pointing out that, you know, it is for the law firm, so that the law firms will say, well, it's the client's ultimate decision, but, you know, clients are very much guided by the law firms. And is it that the law firms are still being old-fashioned in their approach and doing the classic, let's sit around a table and think of some names? Whereas in fact, if you actually turn that on its head and say, we'll sit around a table and talk about characteristics of an arbitrator that we want, that just changes the discussion. You work out, okay, they need to tick all these boxes. Okay, now let's see if we can find names that fit the characteristics, rather than going the other way around, which to my mind leads to appointing a usual suspect. But we're getting some great questions. Thank you all. Please do keep them coming. We have a great question about personal brand and visibility, which I think it is important to discuss. Sapna talked earlier about her putting some questions at a conference and thereby establishing her credibility early on, and obviously improving her visibility in the field. I certainly feel that, I don't know if women in the audience would feel this as well, but I certainly, when I started off sitting as an arbitrator full-time, gosh, 9 years ago now, I had to establish my credibility very, very early on in a conversation with anyone at these type of networking events. And I know perhaps that will resonate with a lot of women. You do feel that you need to get out your experience, your competence early on. But let me ask you generally about visibility, and particularly the question focuses on personal branding. I don't know if, Ravi, this is something you might want to kick off with, and then perhaps we'll hear from Sapna on this. Is that all right, Sapna, or do you want to go first? No, that's great. Ravi, are you okay to take that one in terms of what might best lead to an appointment? Is it speaking at conferences? Is it sitting as a secretary to a tribunal, which we've not talked about so far? I know it's going to be a combination of all those things, but just give us your thoughts on visibility generally.
Thanks for the question, Lucy. This is really a fantastic question, which we could spend the whole hour and a half discussing, actually. But to break it down into some fundamental points, first, I don't think there's any single approach to this which will necessarily work for everybody. It has to be a multi-faceted approach, I think, from anybody who's interested in sitting as arbitrator. You mentioned sitting as secretary, which goes to technical excellence and experience. I don't think there is any substitute for impressing as a secretary or even as counsel. That's all part of getting noticed, especially by the institutions, as Kevin has already alluded to, but also by other people sitting in the room. People remember, if you've done a good job, perhaps in difficult circumstances as a tribunal secretary or as part of the counsel team, notes will be made of that. And you may not see it come back within that same month or that same year, but people do remember. They may have a haphazard approach or a bespoke approach in their organization to keeping records like this, but I firmly believe records are kept. Technical experience and excellence, I think it's necessary, but in the modern age, it's not sufficient just because the marketplace is so saturated by aspiring arbitrators. So I think whilst you do have to find a way to establish your expertise on those hard skills, soft skills are also very important. And I think that can come down to the sorts of things which you were mentioning earlier on, and which Sapna mentioned earlier on, speaking at conferences, asking perceptive questions, just showing people that you're a pleasant person to have a discussion with. Those little things, I think, do add up. Increasing visibility in the modern age, which is the second part of your question, Lucy, I think that does require grappling with social media. I think that does require becoming involved with organizations, doing some voluntary donation of time to assist your local Ciarb branch, for example. All these sorts of things are part of what I like to call a multifaceted approach. And I think, taking a step back to conclude my observations on this, you will never really be able to identify a particular appointment with one specific thing that you did. I don't think it works like that. But what you can, with certainty, speak to are trends. I've seen this time and time again. The people who keep busier, who are more active, who attend conferences, who ask questions, who write, who volunteer their time, they are inevitably the ones who get what others perceive to be lucky breaks. But it's not luck at all, is it? So just some thoughts from me on that. And I'll be very interested to hear what others have to say.
Thank you, Ravi. It brings to mind, whoever it was that said, the harder I work, the luckier I am. And, certainly when I launched my independent practice 9 years ago, it is a lot of hard work. And I love what I do, and I was very, very happy to put in the hard graft. I feel very fortunate to be able to do it. But yes, Sapna, let me bring you in on this in terms of thoughts on visibility and basically moving the needle to get those appointments and to establish a good work flow, because it is a difficult path, as we've discussed.
Well, I endorse everything that Ravi has said, and I just thought I'd share some fun facts with the audience. A few years ago, I attended a seminar on personal branding, which I knew nothing about. And apparently, only 10% of your personal brand relates to your performance. You absolutely have to be very good and impressive to succeed in this field. But as Ravi said, it's not enough. 20% of your personal brand is your image. How do others see you? What do people say about you when you leave the room? I think that Ravi made a very good point. What makes you stand out? Many in our field have cultural dexterity. Do people know about that? A really important part of being on a 3-member tribunal is having people skills. It sounds very basic, but you have to be able to work with people and collaborate. So image is important. Do you command confidence? Do you command that trust that we've been talking about? And 70% of your personal brand is exposure and visibility. Do the right people know you exist? Do they know what you have done? And do they know what you can do? And I know that as lawyers, we were never trained to sell, but I would just encourage everybody to absolutely not think about sales at all. Think about how you can serve. As Ravi said, if you're interested in our field and you're willing to serve and put in the work and do a good job, I think you'll get noticed. Absolutely don't think about selling at all.
Thanks, Sapna. one thing I had to get comfortable with when I started my practice was this notion of self-promotion. And everyone almost everyone hates self-promotion. We're not good at it, as you say. We're usually lawyers, and I do know we have a question about non-lawyers, and I will get to that. But we're usually lawyers. We're quite conservative. We don't, I'm generalizing horribly here, but we're not good at promoting ourselves. And I just gave myself a talking to. And if I don't promote myself, who's going to promote me? Particularly when you're an independent international arbitrator, as I am. You just have to grit your teeth and go and tell people you're a really good arbitrator. Kevin, we have a question, a very nice question from Nicole Smith, asking about how institutions find out whether a potential newish arbitrator has certain expertise. And you rightly mentioned that the LCIA doesn't necessarily look at CVs, but Nicole's asking, what does the institution, how does the institution know about particular expertise and a potentially new arbitrator may have?
Yeah, that Lucy, it goes back to the first-hand knowledge, which I think is quite important, and being able to interface and liaise with the institution. Because I suppose on a CV, someone could say that they're an expert about anything. So I think we really want to have seen it. And I think sort of one of the larger themes that is arising here is the risk aversion and how institutions and nominating parties look at risk. And it's sort of like that stat where you're more likely to get into an accident driving to the airport than on the plane. So I think that because really when you're making an appointment as an institution, and what used to happen, say, a decade ago, I don't think any institutions aspired to appoint a small cadre of arbitrators. I always refer to it as a certain intellectual sluggishness because it just became easy. We've done this before, it worked out well for us, so we're going to do it again. And we think that we have an inaccurate perception of what the risk is going to be to appoint a new arbitrator. I've used this example publicly a few times, but I was really struck by a case I had about 10 or 12 years ago, where you had one of the sort of the leading arbitrators in the world, and you had a small claimant from a 1 or 2 lawyer shop, and the award had been about 18 months since the hearing. And I can remember this lawyer calling me and saying to me, "I know who he is, but it's not fair. My client has a case." And I think that the institutions have moved so far from that where we're just going to appoint people, and even if the performance is not matching the reputation, we are just going to do that before we've done it before. So there has been a lot of advancements, but circling back to the original question, I think that you have to liaise with the institution. You have to show them that you have that experience. And I would also say for any new arbitrators, I think that it's very good to become an expert and get the expertise in a lot of the young sectors that we have. I think it's a bit more difficult to start off as a young arbitrator specializing in oil and gas. But when you look at some of the new industries like crypto and fintech, many of those experts are sort of at a relatively early stage of their career. So getting expertise in a sector where you are going to be somewhat unique and have a comparative advantage, I think that can be very helpful.
Thank you, Kevin. Yes, that's super helpful. Let me bring Caroline in on this, as I may, because we've talked about the fact that party appointments lag behind institution appointments. Chair appointments, which is where obviously you're appointing far fewer people, but I really struggle when I'm a party appointed arbitrator and you get together with your other party appointed and you're appointing the chair. And it's you then appreciate quite how hard the institutions work when they're choosing an arbitrator, because again, if you think your tribunal is important, the identity of your chair, I would say, is even more important than that. So Caroline, obviously you sit full time as an arbitrator, and you'll be experiencing, I'm sure, the same sort of challenges as I do in terms of getting reliable information on good chairs. You talk us through what you take into account when appointing a chair with your co-arbitrator.
Well, it's really it's who you know and trust. It comes back to that trust element again. It's the nature of the case and whether you think someone is going to be a good fit. One of my issues with chair roles is the perception that the chair should do everything, and I think that has to change. There is, in many of the arbitrations that I'm involved in, there's an expectation that the chair should write the award, and I think that is an unfair burden that is put on the chair. Personally, when I'm sitting, I'm always prepared to put up my hand to assist in writing the awards or drafting procedural orders. But generally, my experience is there is a perception that a lot falls on the chair, and I think that's unfair. I don't know whether you agree with that, Lucy, whether that's been your experience.
I think perhaps my view is a little bit more nuanced in that is the perception, but again, I think it was Ravi who talked about soft skills. Forgive me if it wasn't. A lot of our skill in what we do is tribunal dynamics, people management, and again, so to your experience, if there's just this expectation that the chair should be doing something, there needs to be better communication within that 3-member tribunal as to an appropriate delegation, because it is absolutely not right that the chair takes every decision, because then that really undermines the party autonomy that we've discussed and the importance to clients, which is very much endorsed through all the research that's done on this, that clients really want the ability to appoint their own arbitrator. So then if they do that and then feel that that arbitrator's voice is not being heard, to your point that the chair is expected almost to do everything, that's wrong as well. So perhaps I have a slightly different approach to you from that. But in terms of how you choose your ultimate chair, what's your general practice, Caroline?
Well, as I said before, Lucy, it's looking it's the right candidate for the role, particularly if you have worked with someone before and you have got on well with them and they have managed the process well. That's one thing to consider, but it's also the nature of the arbitration. It's also the seat of the arbitration and the governing law. All of those factors come into play. But ultimately, what you're looking for is the right fit for that particular arbitration.
Yeah, absolutely. And that totally chimes with what I was saying earlier about this importance of looking to the characteristics rather than looking to the names. We've got a number of great questions, but let me just pick out one because it goes to the question that I wanted to put to you all next. The question I wanted to put is what common advice about getting appointments is actually wrong? Because I think we should look at that rather than the flip side as to what you can do to get appointments. But the question we have there from Julia, so thank you for that, is advice for an in-house counsel who's preparing to make a switch to sit as an arbitrator. So let me put that to the panel. And if I could ask as well, if you could perhaps one of you just bring in as well, not just the idea that an in-house counsel is switching to an arbitrator, which is obviously not, I would say, in my experience, that common. Obviously, we have some fabulous arbitrators who have only been in-house counsel. More often, they've come through the law firm route. But also to touch briefly on non-lawyer arbitrators, because we had a question in the chat about that, and I think that is something important to discuss. So lots of questions there for the panel. Let me see who wants to put their hand up and touch on the highlight on the first one, which is what advice about getting appointments is actually wrong. I think I see Sapna coming off mute, so go.
No, I was going to answer the second question.
I'm very flexible. Go for it.
Well, bearing in mind that your first appointment is likely to come to an institution, they want a safe pair of hands, as we've discussed. Show an institution, approach institutions and show them that you know your stuff when it comes to arbitration. You would be able to manage a case as an arbitrator procedurally. And you can show that in various ways. You can talk about your experience. You may want to get Ciarb accreditation. Ciarb also has now this fabulous course that we've run in Singapore and other jurisdictions where you may have become a fellow of CIArb and actually done your exams, but you may not have practical experience. So there's a mock arbitration over 2 days, and you actually get to try your hand at being the arbitrator and making decisions. So I think you have to show that you're going to be able to know what you're doing, and there are different ways you can do that. But I think definitely focus on institutions for your first appointments. Look for your local institution and see how you can show them that you do know what you're doing.
Thanks, Sapna. Who else wants to come in on that? I see Kevin and Caroline coming off mute. So I'll come to Kevin first and then Caroline. Thank you both.
Maybe I'll start with the advice that is wrong. Sometimes I hear this suggestion that if you don't take up an appointment from an institution, it's going to be a long time before the appointment comes around again. I can assure you that institutions very much like if you say that you just don't have the bandwidth. I can remember a very high value co-arbitrator appointment where we're making an appointment on behalf of a non-participating respondent. And this co-arbitrator could have handled this as a watching brief. And he said, I just don't think that I have the time to dedicate to this case, and turned down the appointment. Institutions really like to hear this. And I think the error that you can make is taking an appointment when you don't have the time to dedicate it. I've seen a lot of first-time arbitrators who I think are so eager to take that first appointment that they end up getting into trouble. The case becomes marked by delay, and now it's really going to be a long time before the institution circles back to you, if at all. On the in-house or non-lawyer arbitrators, I think there absolutely is an angle there for appointments. Often what we will hear from users is they want an arbitrator that is commercial. And so depending on the sector and the parties, that can be a really big advantage, where those parties would much rather have an industry expert, a functional user, rather than, say, an academic. And I often think back to the Jan Paulsen University of Miami 2010 speech about the moral hazard of party nominations. I think for those in-house arbitrators or non-lawyer arbitrators, when LCIA is appointing all three arbitrators, we can really come up with that balanced tribunal where you might have an in-house lawyer, a procedural specialist, a sector specialist, and getting that cohesive tribunal. So there's absolutely an angle. And I think it's important for institutions to have in-house lawyers. Often when I'm meeting with users, they will ask on the LCIA database, do you have a database? Do you have any in-house counsel? Do you have any lay industry experts that you're appointing as arbitrators?
That's absolutely fascinating, Kevin. And, you know, when I often think of that article, in fact, it popped into my mind when I was saying about, you know, studies show that clients do want to have the party appointment system still in place because, you know, frankly, the statistics would look very different if you got rid of the party appointment system. They really would, if we actually wanted to change the needle on this. But it is something that is very important for very legitimate and good reasons to clients. So we need to be better at identifying that issue, that gap that we've talked about, and identifying what we can do to address it. Ravi, I think you were going to come in on this point. Would you like to do that?
Thank you. I'll just briefly add something. I agree with everything that's been said so far. If you are a non-lawyer, an expert witness, for example, who is interested in adding or moving towards an arbitrator practice, obviously the same points we've already discussed about showing technical expertise and experience and competence, that's all a given. But I would say make sure that stakeholders are aware of your ambitions, that you want to start arbitrating. The number of times I've had discussions with quite senior expert witnesses, sometimes 10 years after knowing them, when out of the blue they will say, oh, nobody ever appoints me. And I say to them, you've never told me you'd like to be appointed. I've had X number of cases over the years where we've had two very experienced legal co-arbitrators, and the case would have been eminently suitable because of the subject matter for a non-lawyer to be in the chair, because between the three, all the necessary disciplines and skills would have been covered. So I would say within reason, of course. Don't be shy about marketing your willingness and desire to sit as an arbitrator, because if the community doesn't know that they should bear you in mind, they're not going to bear you in mind. Thank you.
Absolutely, Ravi, and it's always a slight tension, isn't it? Because I mean, this whole session is talking about breaking barriers, and actually, barriers to entry as an arbitrator are incredibly low. You can get up tomorrow and declare yourself an arbitrator. Absolutely no issue with that. Barriers to getting appointed are high, I would say, particularly for sort of atypical arbitrators, ones that might not be lawyers by training, ones that might not have come through the traditional route of becoming a counsel in a big law firm and acting as counsel in numerous cases, in big cases before, then going out and telling people they are an arbitrator now. But to your point, if you don't tell people, then as you say, how can they know? We have a couple more questions before I'm going to move on to our sort of final session, which is our sort of quick fire round, we've called it. The question that I thought Kevin might take a stab at is this very interesting question about the use of AI tools in arbitration and whether they are going to promote diversity. The reason why I bring Kevin in to this is that Kevin and I are both judges in the Global Arbitration Review Hackathon that's ongoing at the moment. So we have had fascinating insight into some truly amazing, I think, potential products and disruptors in this market through the use of AI and other technology. But Kevin, if you can see Jeffrey's question there, can I ask you to take a stab at it?
I'm not sure if I can find it, but I think that I have this overall theme of the question of whether.
I can just sort of highlight Jeffrey's question. So Jeffrey's asking what our opinion is on the extent the use of AI tools in arbitration will influence diversities, and particularly AI tools looking at the track record of arbitrators. And again, this comes back to the data point that we've come back to a number of times. You're looking at people's track records. Yeah, it's an indicator of future performance and whether AI can help with essentially this data management, I suppose.
Yeah. This is something that I've been speaking about and that we've been looking at, of whether or not we could take all of this information that we have in the LCI database of arbitrators, and in order to confront unconscious bias, where we'd have the initial list that would be generated by inserting specific aspects of the case. So rather than, say, the Secretariat coming up with that initial list that is then put to the President or the Vice President, we have that initial list, say, of 10 or 15 arbitrators that we then vet, and then it goes to the President or the Vice President for appointment. We've also thought about having an outward-facing tool where you would again put in certain information about a case, and it would generate a list from the LCA database of arbitrators, because I think that the institutions and I think appointing authorities, as hard as you may try, you invariably will appoint people that remind you of yourself. And I think that if we could start by getting a list that is based on data, I think that would go a long way, and you would still have the supervision of human beings starting from that AI generated list.
Thank you so much, Kevin. Absolutely agree. Let's just take a general question, which we had in our sort of quick fire round, but actually it might be easier if we just focus on this one thing. We had a number of questions to do a quick fire round, audience, but your questions are so good. We've taken up some time with that. But let me ask Caroline, first of all, one thing that an arbitrator can do right now today to increase her chances of being appointed. And this has come up in a couple of the questions that we have on the Q&A as well. So thoughts on that, Caroline?
Thank you, Lucy. Great question. Well, I think the most important thing that would-be arbitrators could do is to get an arbitration qualification, such as one from Ciarb. And I say that because I think you're more likely to get an appointment from an institution than you are from a party when you're first starting out. And some institutions, for example, I know that this used to be the case with the SIAC, will only put you on their arbitrator panel. SIAC is both a main panel and a reserve panel, if you have an appropriate qualification. Now, I know, because Kevin and I had a chat about this in Singapore some years ago, and I think there is now some flexibility around this. But it used to be the case that to get on the panel, you used to have an arbitration qualification of fellowship or above. So I think that's the one thing, a piece of advice I would give, Lucy.
Thank you, Caroline. And yes, that's it. That's so interesting, particularly as I say, you can get up tomorrow and declare yourself to be an arbitrator, but then, how do you distinguish yourself? And I know the Chartered Institute has done a lot of great work developing these relationships with the arbitration institutions and across the globe. And that, as you say, if you are a fellow, you will be admitted onto their panel. And also, frankly, it's a very, very good training. Was a tutor on those courses for many years when I was in the US, and they are just a fantastic training, particularly in terms of the award writing skills, which is probably the gap, that if you have come that traditional route through the law firms, you haven't had any experience on actually writing the award. Let me ask the same question to Ravi in terms of one thing an arbitrator could do today to increase her chances of being appointed tomorrow.
I think my answer to that would be to focus on some of the softer skills which Sapna and I were speaking about later. It's almost a given in the saturated market of aspiring arbitrators that we have now. The expectation will be that you're professionally competent, whatever your range of expertise is, whether it's as counsel, whether it's as expert, or whatever it may be. So, of course, while I'm not suggesting anyone should neglect those aspects, that's the easiest thing, to do the day job, if I can use that crude phrase, very, very well. But I think this is perhaps something which is more generally true. I always give this advice to my pupils. That is, to go back to my favorite phrase, it's necessary, but in and of itself, it's not sufficient. You have to be approachable. You have to be easy to talk to. You have to be the sort of person who leaves that positive impression with other people. I think these are things, actually, at the risk of being controversial, we don't teach our junior entrants and junior practitioners in a systematic way, the way we frankly should. And so anything you can do to increase and develop those sorts of skills, I think really is a must in today's day and age. The old adage, people do business with people, I think remains so true even in the 21st century. So work on all of that alongside maintaining your technical reputation. And I think that could potentially be an effective approach.
Thank you, Ravi. And I'm going to bring Sapna in on this, but this, what Ravi is saying, really chimes with what you were saying earlier, Sapna, about, I think it was 10% is competence. The rest is, how you make people feel. And that's what they always say about, that's what people remember. But let me bring you in on that. And what could an aspiring arbitrator do today to improve her chances of being appointed tomorrow?
Do you mind? Can I be very cheeky, Lucy, and answer another question?
Please do, go ahead.
Since we're wrapping up, I've just been sitting here reflecting on how we are going to move the needle and, what changes would be very useful. One came to me, and we didn't get a chance to talk about subconscious bias, but it's very real. There is, for many, a perception of an arbitrator in their head that looks a certain way and is male. And I do think there's something small we can do. When I hear people referring to arbitrators as she, which you just did, I actually find it very powerful, because it moves that default perception away from male arbitrators. And I think that it's quite a positive step. It's only semantics, but I think semantics are really important. So that would be one change I would like to see more incorporated when we talk about arbitrators. A subtle change, but I think an important one. And I do think that we might want to think about, to increase diversity, I think having a feedback database, I think it could be very sensitive. That if it includes negative feedback as well as positive feedback, we could probably have a whole session on the pros and cons of such a system. But I do think at a very basic level, I wonder if there would be any scope for having more data on how many cases arbitrators have, so that we have the people who've really built their careers by being excellent, who then reach this level of being an arbitrator where they're appointed by many and they don't seem to have the ability to say no. It will be good to know the level of appointments that are being taken on, so that parties can have an idea of whether it's likely to take a year for an award to be issued in their case. I wonder if there's anything we can do as a community to have better data on the number of cases that arbitrators have.
Thank you, Sapna. Absolutely. I mean, your point about the use of language is so interesting and important. If I may take a minute just to focus on that. I wrote a blog on this, and I pulled it up just as you were speaking. It was back in 2020. I had no idea it was that long ago. But I was quoting the author of Invisible Women, which if anyone haven't read it, please do read the book Invisible Women. And she was saying, when the generic masculine is used, people are much more likely to recall famous men than famous women. To estimate a profession as male-dominated, to suggest male candidates for jobs and appointments. Women are also less likely to apply. The generic masculine is read so overwhelmingly as male that it even overrides otherwise powerful stereotypes, so that professions such as beautician, which are usually stereotyped female, are suddenly seen as male. And so ever since I read that and wrote the blog about that quote, I have been hugely triggered at conferences. We've all sat in conferences where people have been casually referring to arbitrators, and they just use the generic masculine, which is traditional and what's happening. You can but I get very, very triggered by that, because I know that it's perpetuating the stereotype that arbitrators are male. So thank you for highlighting that. All right, I will just bring Kevin in finally on sort of concrete things that an arbitrator can do today to increase their chance of being appointed tomorrow, and then I will wrap up because we have reached our time.
Just as a very practical example, especially if you do counsel work and arbitrator work, I think that you really need to polish your arbitrator CV and think about the factors that institutions, parties, and co-arbitrators are looking for. Of course, I've said that we want to have first-hand knowledge, but it could be the case that I'm working on an appointment and I need somebody that is qualified in a certain law. I think that we want to see, have you worked on, whether as counsel, as arbitrator, certain governing laws, all the seats of arbitration, the sectors, and also the passports that you carry. I have spent a lot of time trying to figure out the nationality of someone. Do they have this second nationality? So you want it laid out in a very accessible way. So I think getting that arbitrator CV where you want it is important. And for first-time arbitrators or for younger arbitrators, I think the power of tribunal secretary work is not to be underestimated. When I see arbitrators that have performed very well on their first appointment, it often will follow that they've done a lot of tribunal secretary work, because there needs to be an understanding that simply being a good lawyer is not automatically going to make you a good arbitrator. You need to be a decider. And so when you've worked on the deciding, when you've assisted with not assisting with the decisions, when you've been around the decisions as tribunal secretary, I think that can be very helpful, and it's a nice pathway to appointment.
Thank you, Kevin. Absolutely. I mean, I would say, capture all the experience that you have. It may seem to be, a small experience in a small case, but capture it so that, as Kevin says, you can bolster your resume, you have something concrete to share with people. Thank you all. We are right at time. I cannot thank my panelists enough for the time that they've given. so that we can all really gain and benefit from their experience in the spirit of this International Women's Day 2026. I wish you all an excellent International Women's Day on Sunday, and thanks again, and really appreciate all the contributions. Goodbye.